This session, succession planning, wealth management, and the risk of not having an estate plan. It's very, very important. My name is Raman Rama. I serve as the chair of the Education Committee at AHOA. Each year, our team works very, very hard to ensure we bring you education that matters, delivered by AHOA peers and industry experts. We need your help to do this. When we get to the audience Q&A segment of this session, please get out your phones and scan the QR code and fill in the survey. I see about 75 to 100 people in this room. I would like to see 100 responses back. For all the good ones, you'll get 0 points. For all the bad ones, you get 10 points. Because that's the only way we can improve. That's why I need your honest opinion about the education sessions. At the same time, you'll be asked questions. What would you like to see in the future conferences that we are going to have in New Orleans next year? And the Education Committee will start working from next week to prepare for next year. That's the plan. We are also planning to have educational sessions at the regionals. And if you say we need these kinds of education sessions at the regionals, say that. Because sometimes these educational sessions that we do here are not done at regionals, and people who cannot attend the AHOA Con get missed out on it. I want you to know, just 3 days ago, I got a call. RP, I cannot be at 2 sessions at the same time because both the topics are good. What should I do? I said, I'm sorry. Maybe one spouse in this room, the others in this room, and then you can switch notes. But finally, Bharat approved recording of 10 sessions. And those 10 sessions will be on the AHOA website in the resource library that you'll be able to see, or those people that could not attend them would come. Now, these sessions that we picked are not in favor of the type of hotel. They are neutral, where the branded hotels can take advantage as well as the independents. If you look at all the topics this year, they are all in such a way where both the kinds of hotel owners are able to take advantage. Would you agree with me? Yes. Thank you. I would like to introduce an esteemed lawyer, Pooja Patel Mehta, all the way from California, one end to the other end of the country, who's going to moderate our session. Now, how we came up about this session is this is something that I have been dreaming for years because I did my estate planning in 2012. I said, if something happens to me tomorrow, I have a heart attack and I pass away, what happens? How is my wife going to take over what I've done? Does she know what I have? Does she exactly have access to those documents? Does she have access to the safes to get the valuables? Or if it is the vice versa, all the ladies manage all the safe deposit boxes in the banks. Husband's signatures are not there. And when the husband goes to pick it up and they say, why? Your signature is not appearing, and you tell the bank manager that you've lost your wife, they will seal that box, and the judge will be having custody of it in family probate court. That's how serious this is. And how many of us pay attention to that? Have you ever thought of that? That all your jewelry, valuables that are in the bank, you have no access to it because your wife passed away and your signature does not appear on it, or your children's signature don't appear on it if something would happen to both of you. That's what Pooja is going to explain, what documents we have to have in file, how they should be created, what kind of help you need, and some ideas of how you can transfer those assets and values to your generation next without having to pay gift taxes. You know how they are talking about in Washington, D.C., about gift taxing and how they're going to limit those transfer of assets and estate and everything because they think the wealthiest people should bear the biggest burden. We've worked our life out for it. Why? We've already paid income taxes on it. Why should we have to pay estate taxes again on something that we've already paid taxes? That's double dipping, right? That's what Pooja is going to explain to us. And by now, I think I've taken much of her time. Pooja, you have it.
Thank you, RP, for the introduction. Good afternoon, everyone. As you can tell, RP, Jesse, and I are really excited to speak about this topic today because, unfortunately, a lot of times succession planning and estate planning gets put on the back burner, right? Our everyday daily life is so busy. You know, if you're in operations, which most of you are, you're always hit with the new emergency that you have to tackle, right? And so thinking about an estate plan and executing a will or a trust is something that you'll deal with later on. But life is full of unknowns. And so it's super important that we put this at the forefront of our mind today. And so today we have two experts in their fields. RP, of course, has tremendous amount of knowledge. He manages and operates his family's company. And so he's going to share tons of anecdotes, I'm sure, with you today that will resonate with you. And then Jesse Darrow, he's also going to be speaking about some of the tax advantages to be had with executing an estate plan. So I'm going to set a few ground rules for today, if I can. If our panelists can share their responses in 1 to 2 minutes, that will help us create a flow conversation and dynamic conversation today. And RP, I know you're already thinking I might break that rule today, so I might have to turn the music on like they do at the Oscars. But if you guys have questions throughout this session, please do ask them. We do want this to be an open conversation and really a dialogue to address any concerns and questions that you have as well. So without further ado, I'm going to let Jesse share a brief bio about yourself and then speak to why estate planning or succession planning is important in your mind's eye.
Well, hello, everyone. My name is Jesse Darrow. I'm a financial advisor with PhD Financial. We're a sponsor at this event, as well as every AHOA town hall in the country. This topic is interesting to me for a few reasons because, as Pooja pointed out, a lot of you will probably not be thinking about this as a priority. It doesn't take a lot of time to create an estate plan, and it also doesn't cost a lot of money. But the value it will create for you and your family and your heirs is significant. So if you haven't been thinking about doing this, the first thing that you should take out of this meeting is, after this, make sure if you don't have an estate plan, you start putting one together. Who do you need to contact to set up an estate plan? Well, there are people like Pooja that can help with this. Our firm can help as well. Any trust attorney or trust company will be able to advise you on this process. But it doesn't have to be too complicated. Any plan is better than no plan. So if you haven't already created one, and you don't have to have jewels and gold and hundreds of properties in order to benefit from an estate plan. Even if you just own a house, cars, anything that you want your heirs and family to be able to easily take possession of if anything were to happen, you want this plan in place. So I don't know if I've already gone over 2 minutes, but that's what I think you should take away from this meeting, and I hope I can answer any questions about that. Thank you.
RP, Uncle, Go
Well,
ahead.
I already took my 2 minutes.
Okay. You have nothing else to add?
And just to add is that it's very, very important to take this matter very seriously. And the hindsight to it is if you don't do anything, you might be just having your home to live in, and the courts will decide who gets what and how much after the government has taken away their portion of taxes. Would you like to be in that kind of a situation? I'm scaring the hell out of you guys, but you should be scared. You should be scared so that you do something about it.
And I'll share a brief bio about myself as well. My name is Pooja Patel Mehta. I am the managing partner of DPA Attorneys at Law. And one of the practice areas that we specialize in is executing wills and trusts for our business owner clients. And we're also a full-service law firm on the transactional and defense side. So to get started, I kind of want to work a little bit backwards. If I can have our panelists describe what maybe one of the best outcomes that you have achieved for a client by executing an estate plan or by helping them succession plan? RP, would you like to start?
In 2012, basically, we did a net worth statement of what we have, and the CPAs prepare those for us, and then they say, okay, you have going to have high tax liability if something were to happen to you or your wife or you both pass away, and you should do something in form of an estate tax planning. So we hired an attorney in locally, because you have to be careful what state you are in, because you have to hire the attorney from that state to prepare the documents so that they comply with the state regulations as well as the federal. And when you change states for your residency, you have to get those documents reevaluated and updated again. In that case, at that time, the limit was like $10 million for each spouse to each child or each successor. So we were able to transfer all those assets at the equity value. Think about this. It's not at the market price of the hotel, but how much equity you have in there. And when you transfer the assets at the equity value, a 10 million equity value could be $40–50 million worth of assets. Think about that. When that happens, when you're transferring those into a trust, that the beneficiary of that particular trust is son A, you transfer 10 million from you, 10 million of your wife. Son B, 10 million you, 10 million your wife. You've already sheltered $40 million, correct? Now what happens is these hotels belong to the trust. All the income goes into the trust. All the appreciation of that asset goes into the trust. When you sell it, all the incomes belong to the trust. No estate taxes. Think about that. When that happened, the attorney said, you still have something to transfer. So I did a purchase sale agreement with the trust. I sold my equity to the trust and created a promissory note. That promissory note is going to pay me principal and interest, and that's my retirement income. If my son says, you don't get anything from here, you transferred everything to me, you are a bad papa, sorry, but adios, I'll say, where is my promissory note? You understand? That's a classic example that people sometimes in tax planning overlooked, and my attorney did overlook. When my son questioned, how do we do this? So my son is a CPA, used to work in E&Y in New York. He says, can we do a purchase sale agreement with the trust? He says, oh yes, we can. So we created promissory notes to be able to cover those. We did a living will, that if I go on any kind of life support, I don't want anybody to take this decision. I don't want to be a vegetation state. I want the doctors to pull the plug. Why? Hospitals are making money. They will keep on prolonging your life support because that's their income. But do you want your family to suffer? That's another thing. Creating a will. And the will has to be updated each time of after you pass away, how much of it goes to who? Daughter, son, siblings. If you don't have any of those, then the next year, my brother's kids, my sister's kids, like the whole family gets wiped off. What do? You have to go to that extent. Or a charitable foundation, whatever you wish. And I'll leave it at that for them.
One thing I would add to that is there are different types of trusts. The trust that he's talking about is an irrevocable trust. This is what protects the assets from creditors and what allows you to transfer ownership out of your name so that if anything happens to you, those assets are not at risk. When I think about what's the best outcome that we've ever achieved with an estate plan, there's two outcomes with an estate plan. The first outcome is being able to easily and quickly transfer your assets to your heirs. That's what he was talking about before, so that your family is not showing up at the bank and having any issues getting access to those funds. So that's part of it. But the other part of it is entirely about taxes. It's all a question of taxes. There are different fees and probate. There are different fees and taxes that are owed anytime you pass away. Some of it is insulated in the sense of if it's not more than $13 million, $13.8 million, you're not going to have an inheritance or estate tax, federal. You could still have, in certain cases, state taxes, which is inheritance tax, but the gift tax or the estate tax is only for very large estates. But nonetheless, whatever it is, whatever amount you have, it's beneficial to have this plan. And if you want to protect those assets from creditors, the type of trust that you need is an irrevocable trust. I have many clients who have saved tens of millions of dollars in taxes by having a proper estate plan set up. Tax rates range from 18 to 40% with estate taxes. These are federal estate taxes. States like Florida, 38 of the 50 states, do not have state-level estate taxes, but certain states do. So not only could you have federal taxes, you could have state-level taxes. And sometimes the taxes are so significant that your heirs actually have to sell your assets in order to pay the taxes. So you think you're leaving them a hotel, but you're really leaving them a bill. So it's very important to think about these things so that you're not leaving issues, you're leaving assets.
Can I add something to this? Since this session is getting recorded, I want to, on behalf of the panelists, have a disclaimer. What we are sharing with you is just our experiences, knowledge, that might not be legally suitable for you all. You need to consult your financial advisor and legal attorneys to create this. Don't just go by what we are saying, but it gives you a direction of which way you need to go, right? Please make sure we are not attorneys. I'm not, at least. I am just a regular IT enthusiast and an accountant. That's all I am. Yeah.
I think we can take a question.
Oh, you can?
Yeah.
Oh, okay. Go ahead.
So, if you have an LLC and the bank has the loan with that LLC's name on it, if you do an irrevocable trust, does that trigger something with the bank or anything?
Basically, what you have to do is give the LLC trust documents to the bank to say you have transferred ownership of the hotel, but you are still the guarantor of the trust. It's still your signature. You are still guaranteeing that partnership or those assets to it. Everything changes after you pass away. Until then, you have full control. Correct me if I'm wrong.
Well, an irrevocable trust can be the borrower, and you can be the personal guarantor. The assets are vested in the trust, and the bank has an interest in those assets if they're a guarantor, if you've borrowed a loan from this bank. But other creditors, if you were to go into bankruptcy or if somebody got a judgment against you personally, those creditors would not be able to seize assets in an irrevocable trust with, as he pointed out, a big asterisk that not all trusts survive in court, so you have to get them set up correctly. One of the things that you brought up was jurisdiction. Different states have different laws about how assets are protected within trusts, and some states are much more helpful in that way than others. One type of trust is an offshore trust. You can actually form a trust in, for example, the Cook Islands, which is over by like New Zealand. They have very good laws. And if you form an offshore trust in the Cook Islands and put assets there, no creditor can get at those assets. As far as I'm aware, that has never been penetrated by a creditor. But there are domestic trusts that have been penetrated by creditors because they were not set up correctly. There was not a clear distinction in ownership between you and the trust. It can't be you by another name. That's why with an irrevocable trust, the trustee is not your wife or your son. It has to be a third-party trustee, somebody that the bank doesn't see as you by extension. So yes, I mean, of course, anytime you're setting up an estate plan, you're going to be speaking with an attorney and you're going to be getting advice for your situation. But generally speaking, having a trust is beneficial, and an irrevocable trust is a protection against creditors in almost all cases.
Jesse, could you speak to the differences between an irrevocable and a revocable trust? Are there any advantages to a revocable trust? And are you basically avoiding all of the different benefits that you have with an irrevocable trust by going revocable?
No, they're both an irrevocable and a revocable trust are what we call living trusts. These are trusts that you form while you're alive, and they cover assets and how they're owned while you're alive. They also speak to, you can have as part of that plan what happens after you pass away, of course, But the idea with the revocable trust is you can break the trust. You effectively own the assets, even in a revocable trust. That allows a creditor to step into your shoes if they got a judgment against you and try to take possession of those assets. Or in the case where you have a trust with a promissory note, where the trust is paying you money every month, the creditor could step into your shoes as the beneficiary of that note and just take those payments every month towards whatever debt they're owed. The benefit with the revocable trust is you can play around with it. You can break it, you can change the terms of it, you can move assets in and out of it. It has much more flexibility. An irrevocable trust is a complete transfer of ownership, and once it moves into the trust, you cannot take it out, or at least the process of doing that is not so easy.
Correct, yeah. And one thing I'd like to add to that is with an irrevocable trust, if you do want to make changes, like Jesse mentioned, you can, but it's a very difficult process because you have to go through the court system and get a court order in order to actually make a change to those trusts. There's a question over here.
Yeah, so my questions are for both of them one by one. But when we, along with his, so let's say if I have a hotel, I gave a guarantee for $5 million, and I gave my personal financial statement saying I have $2 million cash. Now I'm creating my trust, and I'm transferring that $2 million to the trust. So now next year when I'm going to give my PFS, which bank going to ask me, how does that going to affect? So that's one question.
Go ahead.
Sure.
I'll tell you what I do, but.
Well, I can speak to that also from a lending point of view. Because when you're going to a bank to apply for a loan, like you say, they're looking at how much money you have and your assets. And once you move money and assets into an irrevocable trust, they're not really yours anymore. And although you can list them on your personal financial statement, they're not technically in your name. And a bank that's knowledgeable could say, well, if we were to have any issues with you, we can't actually get at those assets. They don't improve your net worth. That's the pro and con of having the irrevocable trust. Whereas in a revocable trust, it's still clearly an asset on your personal financial statement, and you could take funds out of it, per the terms of that trust agreement. So yes, that is a major con of moving funds out of your name, just as if you were sending it to a family member, somebody unrelated to you. It's no longer really adding to your net worth, and it could impact you in future financing, but you take that risk because you don't want these assets at risk themselves.
Right. When we write the promissory note, you say, and let's say if I write it and say I'm getting $200,000 from trust for my personal expense, is that $200,000 on a federal taxable, or because I already paid tax before?
The interest
I don't have
is.
to pay the tax on it.
The interest is.
You're saying if the trust is paying you money, do you have to pay taxes on that?
We talked about before. So if there is a principal and interest or whatever we are, and if I get 200,000, that's my personal income again, right?
Correct, it's taxable income.
And then 13.8 million, you said it's a per person, per child, or whatever that limit is, and each spouse can give 13.8, or is it combined?
It can be structured exactly as he said, by splitting it up per spouse, by effectively splitting it up per trust. That's how he structured it. I'm sure his assets are structured separately as well. If you file separate tax returns, if you have separate bank accounts, if the assets were not in your own name, then it's already been set up. The groundwork has been laid to gain the benefit of both of those federal tax limits when it comes to the estate tax. But if you have more than $30 million in assets that may be going to your heirs and you don't have an estate plan, you need to speak to an attorney so that you know what options you have, especially because if you live in certain states like California, you'll have completely different options than if you live in Florida. Well, or other states in which you might have a state income tax. Florida does not. But we could go through the list of the states that do, and in some states it could be as much as an additional 20% in additional inheritance tax. In most states it's around 10% in the states that charge it.
At the same time, because you are the guarantor of the trust, the banks are looking at you and what you've guaranteed and basically how you're going to support that. At the same time, when you are paying taxes, you are even paying taxes on the income of the trust. Keep that in mind. So in that case, you have to, again, create a note that you gave so much to the trust to pay the taxes. And that money can come back to you. But at the same time, keep in mind that if there are any estate taxes after that, you need an insurance policy. That's what all the insurance agents are selling right now, but they are not thinking. They're saying, oh, you have so much assets, you need to buy so much insurance so that your kids don't have to pay taxes, because where will they get the money from to pay for it? They're going to have to sell their assets to be able to pay those taxes. And that's why they say you buy the insurance to leave it behind for your kids to be able to pay those taxes so that your assets are still protected.
Sure.
In order to shield parents' assets in California from probate, if the assets are in a form of shares in an LLC, how can you actually shield it from probate? Is it automatically shielded because you are a shareholder of an LLC, or do you have to put it in that revocable trust in order to shield it?
I can take that question. You have to have some form of estate planning documents, whether it's a trust or a will that says this is where that asset or this is where the assets within that LLC are going to go once you pass away. That way you avoid probate court. Probate court only comes into play if either there is some kind of discrepancy with your trust documents or your will, or if you die intestate, which means you don't have a will or you don't have a trust.
So I understand that as far as single-family homes and so forth, but I thought that because you are a shareholder of an LLC, automatically the other person who may be your son can actually access that as long as it's written in your operating agreement.
You can actually specify it in your operating agreement as to what happens with your shares when you pass away. Yes, you can. You can specify in the operating agreement, and then if there's remaining members, then they can execute upon what's written there.
So sometimes the LLC agreements are formed such that you cannot sell your share to any person that's not approved by the other partners. But it should also have a clause in there to have a good LLC to say it can be transferred to a blood relative. That sentence, you must make sure all the LLC agreements have, because that's your intention. After you pass away, you don't want your partners to do whatever they want because you didn't leave that sentence in there that they need to transfer your assets to your son, and then son takes control of your partnership share.
So as far as mentioning it in your operating agreement in your LLC is a good idea.
Yes.
But as a second step, should you also be mentioning that as part of your revocable trust?
Well, first, let me just say, even though it's not the most important thing, when you have an LLC, you don't have shares. You have membership interest. And an LLC membership interest is very easy to modify. It's not a public record. Shares are not being sold. All that's happening is your operating agreement is being amended. So most operating agreements will say successors and heirs when they talk about membership interest, because it's a given that if you pass away, the other partners don't just absorb your membership interest. That's got to go somewhere. And usually it's a conversation with your partners in the LLC, as well as part of your own will and estate plan that you want your son or your spouse or somebody else to take over your membership interest. And that should be compared to a corporation where you have shares, where you actually have stock certificates. And if it's a publicly traded company or a company in which those shares can be easily exchanged, that's part of your estate. And that can lead to probate. Who's going to have ownership of your 1,000 shares of Disney stock, for example? So it's much simpler with an LLC, because these are usually smaller organizations. In AHOA, maybe you have 5 partners at most, 10 partners. And everybody knows everybody, and it's easier because it's in-house. But when you own shares in a corporation, this is part of your estate plan as well. It's not just a conversation with the company. So I just want to make that clear.
Yeah, I think to add to that, it's the will or the trust that you execute should be a comprehensive document of all of the assets that you own. So yes, you may have your operating agreement state where your ownership interest is going to go when you pass away, but this estate planning documents should be comprehensive of all of the ownership interests that you have. So it's a secondary protection.
Just along the lines of that membership interest, so when you have an LLC with multiple members, is it possible to still put your membership interest into the irrevocable trust?
Yes.
Yes. One thing I want to talk about, I think it's the next question she's going to ask, is when you have these different types of trusts, not just the pros and cons of them, but how you incorporate that with an overall estate plan, whenever you take ownership of a property, even if it's a partial ownership of the property with membership interest, that is still an asset. It's going to be on your personal financial statement, even if it's only 30% of the business or a fractional share of the business. So yes, whatever your assets are can be vested within a trust and can be governed by an estate plan.
We've touched on this a little bit throughout the conversation already, but RP Uncle, if you could specify some of the specific documents that you've executed through your succession planning process and the estate planning process, I think that'd be really helpful to the audience to understand what direction they need to take.
Then there are three main ones. One is a living will, which is the health and wellness will. Second is your will itself. And third, if you decide from an estate planning to transfer your assets now to your beneficiaries, that's the trust that we are talking about. The reason I'm saying this is as the business matures, the properties appraise in valuation. Would you want to wait for them to be at a higher value before the trust transfer or within the trust? That's how critical the timing issue is. So if you transfer them at a lower equity estate value now, in 5 years, if that, say, $10 million asset becomes 25 or 30, it's in the estate already. But if you wait till then, you are already at 35, now you're transferring it in, there's less room, right? That's what we are talking about, is the timing is important to transfer them when the valuation is low because you have a limitation of how much you can transfer.
Even partial ownership. So even if you only own 30% of it, still that 30% is going to go up in value as the property goes up.
Well,
I have a question. So if I understand right, when you transfer it into the estate or the trust, are you saying that we can put in the value that we purchased or the fair market value when it is transferred?
Well, typically when we're talking about taxes, which is what you're talking about, they're going to look at your cost basis. So this is the amount of money that it cost to acquire, build, and the amount of money that's gone into the property over the course of your ownership. That will go up over time. So it isn't so much that the appraised value is going up over time, but the cost basis may be going up over time. So at a certain point, the value has exceeded what you may be able to get away with transferring without having to pay taxes. Once it's in the estate, there's another type of trust that I'm going to talk about called a deferred sales trust. But just talking about an irrevocable or revocable trust, the whole point of this is so that when it goes to your next of kin, they're not going to get hit with taxes. And the reality is the sooner that it goes into the trust, it doesn't change what the value will be over time, but it changes how much your heirs might be responsible for in taxes. Waiting an increased cost basis could increase the amount of taxable consequence they might have.
A question for you. Say you transferred the assets to the trust, and now that portion of investment in a hotel that was invested in is sold at a higher price, and now you are getting the distribution of those cash. That cash is coming to the trust.
Sold within the trust.
Sold within the trust. Explain that to them.
Right. I mean, the reality with an irrevocable trust is it's like another person you've created that owns these assets. So that trust now owns the hotel. If the hotel is sold, those funds should go back into the irrevocable trust. They're not being distributed to you and creating a taxable event, which is very important. So at some point, all of these assets will be sold, and the tax consequence of that goes up over time. So it's important to have those assets in at a lower cost basis for one, so that you're not being hit with greater taxes at the end, but also any gains that are created from that sale are going right back into the trust. But there's so many different parts that can go into this that may change what's best for you and your circumstances. So the overall point is not so much that this is one size fits all for everybody, that everybody will need an irrevocable trust, but everybody does need an estate plan. Nobody should leave their kids to figure this out for them.
I think this leads into a perfect segue to allow you to speak about the deferred sales trust, because it's a huge tax advantage that could be had. I think most of everyone in this room knows what a 1031 exchange is. Am I right? Yep. Okay. So this is an alternative to a 1031 exchange, and it's quite exciting. So Jesse, go ahead and share that.
So let me just make sure. So everybody knows with the 1031, what you're doing is you're selling your real estate, you're finding some other piece of real estate in 45 days, very short time, and then you're closing on that sale in 180 days. And if you manage to not just do all of that, but follow all of the IRS guidelines surrounding a 1031, you can defer the capital gains. Everybody knows about that program? Okay, well, fun fact, 40% of 1031s end up being disallowed by the IRS. Through audit or through some other means, they determine it was not done right and you still owe the taxes. So you went out of your way to find some property in 45 days, maybe not even the one you wanted, because you didn't want to pay $1 million+ in capital gains, and you still end up having to pay the taxes. So I'm going to give you another way of getting this done, where you don't have to worry about the risks of a 1031 or the very restrictive timeline it puts you in, but you can still defer the capital gains. And it's another type of trust called a deferred sales trust, or DST. A deferred sales trust you can combine with a living trust, like an irrevocable trust. The deferred sales trust nests within it, so you get the benefits of both. All the deferred sales trust does for you is when you sell your hotel or whatever property you have, it can even be your primary residence, which you can't get away with 1031. But any assets can be sold as long as the proceeds of sale is at least $500,000. That's the threshold. Minimum $500,000, which if you're selling a hotel is probably going to be that, okay? Otherwise, if it's less than that, you probably weren't going to be doing a 1031 anyway. But if you have a $500,000 coming out of it, it moves into the trust, the deferred sales trust. And then you use that money in the trust to buy your next property. You can also put it in a savings account, in brokerage account, but you have no 45-day requirement, no 180-day requirement, no asset restriction requirement. So instead of being forced to sell commercial real estate and buy commercial real estate and follow that really limited timeline, if you just sell it and move the funds into the deferred sales trust, then you could sit on the money forever. You could sit on it for years. You could put it in a savings account. Savings account earns 5.5% right now. You could put it in the stock market and wait until you find the right property. Then you go buy it, and you will still get the benefit of the tax deferment. There has never been a deferred sales trust that has been disallowed by the IRS. It has a 100% success rate. So it is a safer, cleaner, better way of getting all the benefits of a 1031. And you combine this with your estate plan so that your kids end up inheriting the deferred sales trust as part of your estate. So I'm pretty sure most of you have not heard of a deferred sales trust. So if you have any questions, let me know. But again, these are two different types of trusts. One is your estate plan, so your kids can get the properties easily, and there's no probate, and they know what to do if you're in the hospital and with the feeding tube. All of that's in the estate plan. The deferred sales trust is just to defer the capital gains indefinitely.
If I can just use a lighter moment sentence to what he just explained, it is an IRA account for your sales. Right?
I love that.
It is not taxable until you withdraw. So similarly, all the gains and everything is sitting there, and you are not having to pay taxes. So it's like a IRA account for real estate.
Like a Roth IRA, where you don't pay taxes in the beginning, and you also don't pay taxes when you draw the money out. So a Roth IRA, you pay the taxes in the beginning. It's taxable at the time that you put the money into your account. But when you pull it out, when you're 59 and a half, you pay no taxes. So if you're my age and you're putting the funds into the Roth IRA for 20 plus years, it's compounding over a very long period of time, tax-free. And when you pull that money out at the end, it could be a really big number and you have no taxes. The deferred sales trust is exactly the same. You put that money in, it's tax-free, and over 20, 30 years, it could accrue to some huge number not having to pay these taxes. Now, if you pull the money out of the trust, you want to go on a vacation, you have medical expenses, those things. Money that you pull out of the trust is taxable, just as money that you pull out of your IRA is taxable. But you can leave it in the trust. And most of the things you would be using that money for, buying a house, buying a car, buying artwork, buying furniture, you can do all of that within the trust itself. So those funds do not create a taxable event.
And just as a clarifying question, Jesse, let's say that one of the audience members is selling a property for $1 million, and their cost basis was $500,000. Are they transferring the full $1 million that they're receiving in sales proceeds, or are they only transferring that $500,000 gain?
Full sales proceeds. Okay, your taxable consequence is the difference between the sale amount and what your cost basis was. So you're only deferring $500,000 in taxes, but you've moved $1 million into the deferred sales trust, and that's immediately investable.
But the full $1 million is required to be transferred, or only the $500,000?
You can move however much you want, because unlike a 1031, you can pull money out of a deferred sales trust. You could put the $1 million in and take $500,000 out, and that $500,000 will be taxable in the same way as if you only had moved $500,000 in and kept the other $500,000. So you don't have limitations in pulling money out, you just get hit with taxes if you do.
Sorry, could I have somebody turn the lights back on in the back? I think someone switched it off there. Thank you.
This makes perfect sense when I have my own hotel and all that. But how about 4 of us are partners, 25% each, and we get how does that?
So there's no issues with partnerships. In a 1031, if you're familiar, there are issues with partnerships. It creates all sorts of complications because partners have different goals and objectives, and the 1031 is restrictive about how you can handle that. But the deferred sales trust is personal. So if you have, just for easy conversation, let's say 4 partners, 25% each. You sell for $1 million. Each partner can have their own $250,000 deferred sales trust. Or 3 of them could have $250,000, $250,000, $250,000, and the 4th partner says, I don't want to deal with that. Just give me my money, and that's no problem. So each partner, based on their percent ownership and an agreement with the partners, gets however much they're owed. So there's no issue with just splitting it up with partners.
Hi, for the deferred sales trust, you said there is no restrictions on the assets. What kind of assets? Now, is the operating company and the real estate both are allowed to do the transaction in the deferred sales trust?
Do you mean...
So if it's like a business value is separate than the actual real estate value?
Well, let's just go through that example. So you're selling a hotel, and the hotel has different ways in which the value breaks down. Real estate, FF&E, business purpose value, right? Or goodwill, okay? All of that is irrelevant for the purpose of the deferred sales trust because they're only looking at proceeds of sale. So that doesn't matter.
How much cash did you get?
How much cash did you get? And it can't go to you, just like with the 1031. If the money hits your account, taxable. The IRS calls this constructive receipt. If you receive the money, instead of it going to the 1031 exchange company or instead of it going to the deferred sales trust, it's taxable. You can't take it back. So it's very important that if you're going to sell your hotel or sell your house or sell whatever business you have, that at least 2 weeks before your sale, you reach out to start setting up the deferred sales trust. Once you've sold it and the money hits your account, you can't then put it in the deferred sales trust because the taxable event has already happened. So that's not the question you asked, but that's a very important thing, is there is a timeline here. There's no 45 or 180 days after you've sold it, but 2 weeks before, at least 2 weeks, to give the trustee time to set everything up. You want to be starting this process.
So when I go back and just make another investments after the DST has been established and when you want to reinvest, I can go and make that investment into any assets.
Not just can you make it into any assets, you can use it for construction. So let's say you sell a hotel and get $1 million. Now there's $1 million in your deferred sales trust, and you want to go build a hotel for $5 million. You can use that $1 million as a down payment within your deferred sales trust towards the construction of a hotel. Now when that hotel is being built, it's going to end up being owned by the deferred sales trust to continue getting the tax benefits. But the way you can use that money is very liberal. There's very little restrictions with the deferred sales trust as how you can use the proceeds, as long as it's for investment purposes. So again, not family vacations, not medical expenses, not gifts, but stocks, bonds, mutual funds, art, houses, cars, land, anything. 1031, only commercial real estate. DST, any asset.
We are running out of time here. I just want to touch on one topic before we end. RP Uncle, you and your family have built such a powerhouse of a hotel company. And topics like succession planning and estate planning are very sensitive and delicate. How would you advise the audience in navigating the family dynamics and having this conversation of planning?
One statement I will make. Family relationships are family relationships. Business is business. Don't mix the two. Let your documents dictate the terms and conditions of your partnerships. No emotions involved. That's one advice, very critical. If it has to come to a point that the relationship is going to sour because of that, tug of war, you have to just point those individuals to the legal documents. Hey, it's not me. It's the legal documents saying this is what should happen. This is how we decided to be partners. This is how we decided to do business. It's not brothers decided at that time, or sisters decided, or family members decided. But we all decided when we were in good terms to create this document that this would be our governing document. Correct? At that time, no emotions or egos should come in the way. And that should be clear from now. You have to express yourself now to let them know that if in future something were to happen, the documents that the legal attorneys have created are the guiding principles and guiding terms and conditions of conducting this business and relationships. It's not based on my brother or my sister or my uncle or my aunt. I hope you get the message. So that's typically how it should be done. But if something is not happening like that, go ahead and tell it right now, because if you let them keep on doing it, they will have assumption that it's okay to do it. So you have to sometimes put your foot down to say, hey, sorry, look what this is.
Yeah, go ahead.
Going back to irrevocable trusts, when we're trying to vest assets within the irrevocable trust in order to protect those assets, is that a taxable consequence, or is there any type of taxes that need to be paid from that shit?
No. So moving funds into a trust in and of itself does not create a taxable event. In fact, keeping them out of the trust is likely what's going to create your taxable event. It's just important when you have loans and other things that all of these conversations include your lender, so they know what you're doing. And if you're going to be borrowing money in the future, just keep in mind how a trust may impact that.
I know there's a lot more questions. I do think that we're out of time right now. So just some final thoughts. Please ask your questions after the fact. I think we're going to stick around, so we'll be happy to field some questions. But I really do hope that you guys were able to take away some valuable insights in today and really understand the importance of executing these estate planning documents, because you have millions of dollars of assets and you want to make sure that there's a plan for the future, and life is full of unknowns. So take the time and plan. Thank you.
I am not going to answer any questions until you fill out a bad survey on us.
Please fill out the survey.
Please fill out the survey, because it's very, very important for us to know. Just say you didn't get anything out of this session, that's fine. So we can bring better speakers on this stage.
Not enough time. Need more time.
This can be repeated at regionals. Keep in mind, if you make a demand that you want this repeated at the regionals where more members can take advantage of it, hey, make the request.
And also, I'll be at booth 1913. So if you have any questions, you can head over there, okay?
Thank you very much.